Looks like we have a great group. So let's get started. Hi, everyone. Thank you so much for joining today. My name is Jennifer Cook. I'm the Director of Marketing at the National Cybersecurity Alliance. And this webinar is on privacy law made simple. It's part of our full lineup of events for Data Privacy Week. We've been hosting a ton of events on different topics. We have a webinar, a recorded webinar on kids privacy from yesterday. We'll be doing a webinar on Friday on data deletion. So if you haven't checked out our full lineup, please visit our website. All of these webinars, including the one today, will be recorded and made available to attendees, and you can also find them on our YouTube channel. So we'll get right into it. I want to introduce Justine Phillips, our speaker. She is a partner at Baker McKenzie in the Data and Cyber Practice Group, where she provides strategic guidance on data, cyber privacy, and AI matters. So, Justine, I'll let you pull up your slides and just for everyone's awareness, we do have a Q&A box here. So if you have questions for Justine or for NCA at any time during the webinar, feel free to put those in the Q&A box. We'll try to get to as many of them as possible by the end of the session. And with that, Justine, I'll let you take it away.
Well, thank you so much, Jennifer, and to the National Cybersecurity Alliance. I am so thrilled to be joined by so many of you today. One of the downsides of having this in presentation mode is I can't see a bunch of your comments, questions, and I'm very much a people person. So I would love for you to stay engaged. Put in comments and chats. Jennifer's going to be monitoring that and popping in with some of your questions. So privacy laws made simple, 30 minutes, and it's a very big topic. So I'll get right into it. We're going to do a little story time as well. First, just a smidge about me. I'm a partner at a law firm. I specialize in data and cyber, and my practice really focuses on data and cyber laws around the world. Baker McKenzie is one of the largest law firms in the world. We have about 6,500 people in over 74 offices in 50 countries. What that means is that we get to see these laws emerge around the world and compare them across the board and see where there's similarities. I mostly represent companies and help companies comply with these laws. Uh, I also wrote a book, which was a real labor of love, and it was through the pandemic. And I had two co-authors, which were a treasure, wonderful humans, Matt Stamper and David Goodman. And a lot of the content that I'm going to cover today comes from the book and the joy of writing a book over 2 years with two co-authors. So first, I want to begin with data. And what we're looking at here is one of the very first evidence of data as it exists from humankind. 67,800 years ago, this handprint was found in a cave in Indonesia. And why am I going back so long? And really, I want to compare the first evidence of data to where we are today. And I think it really helps explain why the laws have rapidly transformed on these issues. So there you have a hand reaching out into the future saying, hello, we're here, and communicating with others. The first evidence of a writer and an author is this fabulous, fabulous human named Enheduanna. And Enheduanna was from Mesopotamia. And what was so fabulous about her was she was both a poet and a priestess to the moon gods. And what you're seeing here is a depiction of Enheduanna, but also those are the tablets that were discovered. She was Sumerian. Her name meant ornament of heaven. But what was very interesting about her is that a lot of people don't know she is the first author and creator of data in humankind and civilization. So she is a real star of where we begin with our data and how much data there really is. So this digital revolution and data privacy obviously has changed quite a bit in the last, I'd say 2018 was a pretty landmark year in the world of data privacy globally. It was the year we had GDPR go into effect. It was the year California Consumer Privacy Act was passed. And the reason being is the digital revolution, we have massively changed the amount of data that we create as humans. Since the dawn of time, since that very first hand that reached into the future, there was about to the present, I'd say to about 2000, early 2000s, there were only 5 exabytes of data ever created, ever created. Fast forward to today, with the rise of the internet, connected devices, lots of data being produced by humans and computers and machines, we create in a year about 181 zettabytes. So we are rapidly transforming the amount of data that we create as human beings. And so humans create data. We create books and poems and all types of things. But machines are creating a lot of data. And so we'll talk a little bit about the machine created data, individual created data. But before we go to data, let's talk a little bit about what privacy is. Lawyers love words. And so I often begin when I think about a complex topic with the etymology of a word. Where did this word come from? What does it mean? Some languages in around the globe do not have a word for private or privacy. It's not in their language. But privacy is rooted in Latin, and privatus meant belonging to oneself. So there was this publicus and there was privatus. So it was the opposite of public, that dichotomy between the two worlds. It meant to deprive oneself of publicity. It was your own individual self and state. And that was in about the 14th century. Fast forward to the 15th century, the first time we saw the word privacy, and it was really this quality or state of being private or belonging to oneself and not a public. So privacy itself around the 15th century really started to take root. And so why does this matter? Privacy today is really about an extension of our individual selves. When we think about data privacy and the laws that we're going to shortly talk about, this is really about an extension of the data that exists that relates to one's own self. And definitions of personal information really relate to an individual in combination with some sort of data element about that individual. And I'd say before 2018, there was somewhat of a sense of privacy and self, but it was rapidly transformed because as companies possessed data, there was somewhat ownership of the data. And the laws very much said, a company that owns or possesses data. So it felt like it was theirs. This concept of possession is 9/10 of the law. But what changed in these comprehensive privacy laws is that the data privacy and rights to the data were given back to the individuals. So that is in the US, in the United States, a very interesting concept. So, how do the laws evolve? Where do they come from? A lot of folks are very interested to know that there is no US constitutional right of privacy. This is one of the reasons we do not have a federal comprehensive privacy law. This is a obligation that has fallen on states to regulate, which is the right place for states to be. Each state has their own constitution. In fact, there are 10 states in the United States that have an explicit constitutional right to privacy. It'll come as no surprise that many of those states also now have comprehensive privacy laws. California is one, since that is where I am. This is where I live and breathe. I was born, raised, and educated in San Diego and never left. And my office is in Los Angeles. So when we think about these privacy laws and where they have come from, they come from a place of people wanting to keep their information and data private. So, the very first privacy law, comprehensive privacy law that we saw in the United States was in California on the heels of the Cambridge Analytica scandal. And what that law said and did is that California residents would have a fundamental right to privacy, which they also had a constitutional right to privacy. And then they gave certain rights to individuals. Well, California had also been the very first state in the country to require businesses, if their data was compromised, to give notice to those individuals. And so that was 2003. We had that very first breach notification law. And since that time in the United States, all 50 states have a breach notification law. It took some time, it took about 20 years, but all the states eventually got there. With comprehensive privacy laws, again, 2018 was that landmark year. So we saw that law get signed. It went into effect in 2020. And this picture here and heat map really shows that other states are quickly coming along. Other states and IAPP does a really nice job of tracking state privacy. So you can see here, the green is all the states. There's 20 of them now that have comprehensive privacy laws. And there's lots in flight. So some of the issues that get delayed are, we going to have a framework similar to California, or are we going to have a framework similar to another state? And are we going to have a right to sue? And so these things can get delayed. And so, from a political perspective, privacy has also certainly been a political topic amongst our parties. All right, so what are these privacy laws and what do they do? So these privacy laws are rooted in giving data back to the individuals. And it's interesting because we have this real, I'd say, paradox happening. Because as individuals using these technologies, which are amazing and they change our lives and they make things more convenient, they give us information we didn't otherwise enjoy. They remind us about things as we're shopping, whether online or otherwise. And so there's a lot of benefits to how we live and interact with the world today. But what these laws said is individuals have a right to know what information is being collected, who that information is being shared with, how it is being used by a company. Well, that was pretty new. We had other privacy laws, which are like Shine the Light and other types of laws that required privacy policies, those that you'll often see on a website. But this really changed what we had to say in those privacy policies. So the right to know is really about disclosures. You'll also probably know from interacting with websites the last 5 to 7 years, there's been a rise of banners about how you use a website. So that is not true for, I know we have a really good attendance from people all over the country. You may not get a banner in your jurisdiction, but in California, very, very common now that a cookie banner will be displayed. That cookie banner might have to have very specific explanations about what type of cookies, pixels, or tags or tracking technologies are being used on that session. There are certainly new technologies like GPC, a global privacy control that an individual can enable, and the website has to recognize that and essentially sends a signal and it says, don't track me, don't put any cookies or tags on my session. And so it's an automatic opt out. We have a right under these laws to opt out of the sale of personal information. And what I picked up here, this picture graph, you'll see that it says locked. That's lifted directly from Cal Privacy. That is the agency that enforces California Consumer Privacy Act. And that particular agency has come up with this nice little acronym here for the different rights that it provides. But the opt out in California, we call it the sale of information. It doesn't necessarily mean the company is selling your information. More often, it means they are sharing it with a third party. And so that is very much regulated by California law and many other states, as I'll show you in a moment. You also have a right to correct and delete personal information. Personal information is defined under these comprehensive privacy laws. You have a right to access and request access to your information that may be collected. There are multiple exceptions to that, but you generally have a right to access information the business may have about you. This a big one that you probably heard about is this right to delete personal information. In Europe, this is known as the right to be forgotten, and that information is not that right is not absolute. So you can make a request, but there are many exceptions. So, for example, if you bought something with a company and then you submitted a request to delete, the company doesn't have to delete the transaction because there are other laws that require them to maintain that data. But there's other information and ways that you might have this right to delete information. So it's very complex law. And many businesses in the last 7 years since it went into effect have been changing disclosures, banners, technologies. There's privacy enhancing technologies that are used to help companies with cookies and jurisdictional geofencing. Ones like you might have heard OneTrust is a privacy enhancing technology that helps simplify some of these things. So these are the general rights. And I'll just show you that as a business, doing business in the United States can be difficult. And that's because these rights sometimes look different across different jurisdictions. So you can see here the state, and this is the rolling effective date. You'll see here California, it actually went into effect 2020, but then CPRA updated it in 2023 and gave additional rights. So the rights are different depending on the jurisdiction where you are. The way these laws apply, it's where the individual is domiciled or has its residence. So companies do not enjoy privacy rights the same way individuals do. In the United States, you might have heard this term data subject. Data subject is very much a GDPR term. In the United States, we use a term called consumer, and consumer privacy is the body of law that really oversees this type of comprehensive privacy right. So from a rights perspective, just depends on where individuals are, and companies have to determine those rights based on where the individuals are. In addition to the rights we already discussed, which are these rights to access, correct, delete, opt out, there can also be certain rights to appeal. In the California, there is a very unique right to sue a company. There are statutory damages, fines, and penalties if certain types of data is compromised. So the private right of action is not absolute. It is a sliding scale for statutory damages between 100 and 750 per person. But it's only if very specific types of data have been compromised is when that right to sue would rise. As you can imagine, this gives rise to lots of litigation in California and lots of reasonable security requirements as well. California also recently, effective January 1, 2026, passed more landmark regulations that will require businesses doing business in California to do third-party cyber audits. There are also independent audits that can be conducted internally, but again, this is a very new audit requirement. It will require a member of the leadership team to sign attestation under penalty of perjury that the audit was conducted. There are very specific technical security controls that have to be conducted. And if the company does not comply with those technical security controls, they have to explain why in their audit. So this is going to the first filing requirement will be in 2028. But this is a very, very big and much like 2020, probably will change how other states look at these cyber security requirements. So you'll also see there's some risk assessments. Again, notice and transparency is a very common across the board for disclosures. And then data minimization as well. Companies have an obligation to only process and limit the retention in which they keep data. One other unique factor for California is that it does apply to employees and business contacts. And that is unique. And that is, again, the only jurisdiction in the United States that affords that right to its residents. I wanted to mention a few other privacy laws. We really focused on comprehensive privacy laws, and I was trying to make it simple. I hope I accomplished the call and the mission. Uh, but there are many, many other privacy laws. In the United States, traditionally, we would very much focus on laws like HIPAA, GLBA. It was hyper focused on types of laws and the types of companies that had to comply with those laws. So if you've ever gone to the doctor, you know you had to fill out a HIPAA form and consent disclosure, but that only regulated health information. Financial information, for example, you go to your bank or a financial institution, is going to be regulated by Gramm-Leach-Bliley Act. And so that was very focused on disclosures and that type of information. So what we talked about today was comprehensive privacy laws, which was brand new in the US starting in 2018. Other privacy laws that are really getting a lot of attention in my world these days are wiretapping laws, like the California Invasion of Privacy Act. That is a very old law that was about wiretapping. It was hyper focused in the 60s and 70s on governments wiretapping phone conversations of citizens. And this particular law has, in recent years, been interpreted by plaintiffs to attack cookies, pixels, and tags and tracking technologies. And so what we see is a lot of lawsuits brought against companies, demand letters seeking statutory damages under SIPA, arguing that the use of cookies and tags and pixels violate SIPA. The problem with that in the United States, as I mentioned, is we are an opt-out country. So when you visit a website, all you have to do is opt out. What plaintiffs bar is arguing is SIPA requires an opt-in requirement, that you can't use any of these technologies until somebody affirmatively consents and opts in. Well, that creates a lot of confusion, and there's a lot of litigation and opinions right now that are very focused on SIPA and why it shouldn't be interpreted that way because of the confusion that it creates. There's also rights to physical privacy. Again, the Fourth Amendment search and seizure, that is built into our federal United States Constitution. That particular Fourth Amendment right has also been interpreted by our United States Supreme Court to also afford and extend somewhat of a privacy right around issues like Roe v. Wade, the right to personal body privacy. Another type of law that I'm sure you are tracking and hearing about are AI laws. These are very focused on how businesses use technologies, whether they have to tell you they're using them, whether you have to have consent, can you use the data to train models, LLM models. So there's a growing and emerging area around AI laws. And finally, those breach notification cyber laws. This is about securing the data that you have. Um, when we think about privacy law, this isn't about just a disclosure. This isn't about telling people what we're doing. This is about how that disclosure and how that activity really is integrated with your technology. So, how technology works is an incredibly important part of making sure that we comply with these privacy laws, but also having consumers and individuals understand how technology works is also a big part of it. Remember that paradox I mentioned? That paradox is about we give up so much information in our daily lives. But then there's this expectation that we want to contain it, and maybe we want to be private and exercise our privacy rights. So there's this disparity between what we're doing with our technology and what we fundamentally as a value want to happen to our privacy if we wanted to keep something private. Also, the third leg of the stool here is process. So people is understanding who those people are, who's going to regulate and monitor. The technology is, what is the technology doing, and is it consistent with what we said it did? The process is about things like if somebody submits a consumer request, how do we process that request? And what are our documents and our written policies related to it? The scales of justice always making an appearance here, and this is about risks and benefits. Again, I think this also applies to both individuals and businesses. There's risks and benefits to the collection and use of data, but also in what is shared. And I do want to leave a few moments for questions. So I'll leave with some wisdom for RBG, which is real change, enduring change happens one step at a time. So I will leave that as my last slide and take some questions, Jennifer.
Great. Thank you so much, Justine. We do have some questions in the Q&A box. So let's see. Someone asked if I have an online store based in Pennsylvania and someone from California buys something, is there then an obligation to comply with CCPA?
Yes, there is an obligation. If you are making generally a website available, you will have to comply. But California has some thresholds, so you have to make a certain amount of money in order to have that law apply. So that threshold initially was 25 million, and it sort of incrementally creeps up. So if your gross annual revenue is 25 million plus, then you will need to comply with California, even if you are not in California.
We have a question here. Is our federal government behind in having a national right to privacy? And I know we only have a few minutes left, so I don't know if we have time to get into global privacy laws, but maybe you could just give us a kind of little overview of
my op-ed
what's
piece,
going.
my op-ed piece. I think that privacy rests with states, and both our federal and state governments would agree with that, uh, because there's no federal right to privacy, but there are state rights to privacy. So I think we've simplify things in some ways, but I don't think that federal laws should preempt state laws that are stricter.
Um, we have time for one more question. So here's one. Other than cookies, it seems that companies make it difficult to find what data they collect and what they do with it. It's usually buried in a privacy notice or terms of service. So getting data removed seems pretty cumbersome. Do you have any advice on how a person could start to clean up their data exposure given these
Yeah.
challenges?
Fabulous question. Data destruction and retention is critical. There are many, many good ways to do that. There are automated technology and tools to help identify classified data. There are automated settings that you can put in a lot of apps that are going to burn down data that you no longer need. There are ways to anonymize and pseudonymize data so you can keep the data for aggregate purposes, but not include it for an individual person. But having that on your roadmap is an absolute best practice and highly recommended to comply with these laws.
Um, let's see. Actually, I have time for one more question because we're getting some questions about privacy breach settlement information. So someone asked, companies have sent letters of privacy breach settlement information, and it can be confusing to follow or to know for sure if this is legitimate. This person says, I normally disregard because I'm not sure if it's a scam. Are there any resources or steps that can help with this information? I think a lot of people have received these like settlement
Yeah.
notifications and we're never quite sure what to do with them.
Also, a fabulous question, and that's where I spend a lot of my time helping companies investigate cybersecurity attacks and then prepare these notices that you receive. So, first, we're living in a time in a world where threat actors have weaponized artificial intelligence, and so there's going to be more of these notices. Just know that. If you receive a notice, I highly recommend that you subscribe and sign up for identity theft protection services. There's a fabulous nonprofit. It's actually headquartered in San Diego called Identity Theft Resource Center. This is a free consumer protection agency that provides. They're not an agency. They're a nonprofit that provides lots of incredible resources. So if you're ever wondering, they also have a call center and a hotline. If you're ever wondering, is this legit? They track all breaches. So I highly recommend availing yourselves of credit monitoring, ID theft protection. Although companies can comply with every law under the sun, there's still risk. And that's because we are in a really difficult time with cybersecurity attacks. It's going to take all of us doing it together. And thanks for Jody for dropping that in the chat.